Morning, everyone, and welcome to the Virginia Bar Association Practice Management Advisor Call. I'm Paul Fletcher. I'm the Executive Director of the VBA, and it's my pleasure to welcome you this morning. These are monthly calls. We've taken August and September off for the summer, but we are now back on schedule. These calls provide valuable information on interesting topics that will help you practice law better and more efficiently. We have a great lineup this morning of speakers. First, I would like to welcome Sharon Nelson and John Simek of Sensei Enterprises, who are here this morning to talk about cybersecurity and new ethical considerations on that topic. One of the things I should remind you is that this is not legal advice. It's an exchange of information among colleagues to try to make law practice better and more efficient. So John and Sharon, it's great to have you back on the program, and take it away.
Well, thank you very much, Paul, for inviting us. We're grateful to be here. We're going to talk to you a little bit about some of the radical shifts in the ethics of law firm cybersecurity and what's reasonable today, which is something that everybody is concerned about. But I thought I would start off by letting you know a couple of stories that are maybe of interest to you that a lot of people won't have caught up with. One story is from Reuters, and it came out in July of this year, and identified 35 legal cases in which Indian hackers attempted to obtain documents from one side or another by sending them password-stealing emails. The target's lawyers were often targeted. They tried to break into the inboxes of more than 1,000 attorneys, and they tried to break into more than 100 different law firms. Among them were some global practices. So, I mean, some of the big players were there. And what was really perhaps the most astonishing fact about this story to me was that one of the persons contracting for getting into someone else's litigation file was a lawyer. And that, I think the disciplinary folks would be most interested in talking to that person. So that was one of the startling stories. And then something else came up not too long ago from New York that I thought might be of interest. And many of us, as we take an app and we download it, looks good, this app, right? We want it. And a lot of times they ask us to share their our contacts. Well, of course, that's never smart, but people do it all the time. And the New York State Bar Association has actually issued an ethical opinion saying that you cannot share your contacts with one of these apps unless you can reasonably conclude that no human will view the confidential information and that the information will not be sold or transferred to additional third parties without the client's consent, which of course you're never going to get. So those are a couple of interesting stories from not long ago. But what we want to talk about primarily today, and there are other rules impacting ethics that have to do with cybersecurity, but the two major ones are rules 1.1 and 1.6, competence and confidentiality. The standard for both compliance with both of those is reasonableness, but what is reasonable has sadly changed over time. As we know, well, there is no set it and forget it in cybersecurity. It changes not only year by year, but month by month and day by day from our perspective. John and I have had the great privilege of working with and speaking with legal ethicists across the country. So what we are telling you today is very much in keeping with what not only we are saying, but with what others are saying. And so the measures we're going to talk about are deemed reasonable. For a very long time, law firms believed that their servers should be on their own premises, that it was dangerous to put law firm data in the cloud. Since the pandemic hit, we've seen virtually all law firms move their data to the cloud if it wasn't already there. John, why is that so critically important now as a cybersecurity measure?
Well, I think primarily it's at the end of the day, the cloud is going to protect your data a heck of a lot better than most law firms, most attorneys are. Now, having said that, unless you're, one of the AmLaw 10 or whatever you want to say that are spending tens of millions of dollars a year, you don't have full-time staffs doing this. The cloud providers do. They have full-time security professionals that their sole purpose in life is to monitor for data breaches, monitor for hacking attempts, apply patches, change their configurations, make things as secure as possible for folks. So that's really the primary reason that you want to get to the cloud. But there's some recent examples, most notably Microsoft Exchange Server. I know we have one client, I think, that's a holdout that still has one on-prem, where everyone else is in the cloud. But Microsoft Exchange in the last couple of years has been under attack. The first, I think it was at the end of last year, if my memory's right, 4 zero vulnerability were discovered on Exchange, were being attacked. Not just attacked, period, but attacked by state-sponsored attackers. That's pretty frightening, in and of itself. The good news is that the Exchange Online, in other words, the stuff in the cloud, the Microsoft 365, was not impacted. Just recently, within the last 2 weeks, 2 more zero-day vulnerabilities were announced for Exchange. And guess what? State-sponsored attackers are hitting those guys. So within a couple of years, having at least 2 separate instances of attacks on on-premise servers, I don't know about you folks, but that gives me pause, and I'd rather be in the cloud.
Yeah, the clear advice to all law firms is get your
Yeah.
data to the cloud, get them off of your own premises.
Well-
There's no one I know that disagrees with that.
Well,
advice at this
the other
point.
advantage too is it makes your life a heck of a lot easier, especially as we move more into a hybrid workforce, right? More mobility. It facilitates mobility a heck of a lot better.
It certainly does.
Yeah.
And perhaps the most striking change of the past year has been the clear advice of everyone in cybersecurity that enabling multi-factor authentication is the single most powerful cybersecurity move that law firms can make, and it's often free. Also, you might consider that cyber insurance firms almost across the board are demanding when you go to renew your policy that you enable multi-factor authentication. And of course, if you say you did and you didn't, you're not going to get recovery from anything. So John, would you talk a little bit about why multi-factor authentication, in spite of being a little bit of a pain, is so very important?
It really depends on how it's implemented.
Right.
What's happening and what we're seeing today is that, the sad reality is that password hygiene for users is pretty crummy. They're reusing passwords, they're sharing passwords, they're using weak passwords. What is it? Password 1234 is still the favorite, or one of the favorite top 2. So when you have that going on, plus you've got attackers that are compromising databases and authentication credentials from various organizations. And what do? Is they take that information and they use that as seed, because they know people reuse. So they're going to get, a pretty good high success rate. So how do you prevent that? Well, or how do you mitigate it more appropriately is you use a second factor, so that even if your credentials are discovered, and even if they are stolen, the attacker doesn't have that other device, right? Doesn't have your phone, doesn't have your computer, doesn't have your laptop, that token, whatever it is. So Microsoft's own review of the data when they implemented two-factor authentication, that 2FA or MFA, multi-factor authentication, blocks 99.9% of attack takeover attacks, credentials compromises. So that's pretty darn good. It's not 100%, but it's pretty darn good. Now we could go spend all afternoon talking about the reasons why and the excuses, but we're not going to do that. Maybe even to help you a little more, Google, when Google implemented they have a hardware token for their employees. It's called a Titan key as their second factor. They have yet to have a single employee's credentials compromised. 0.
Yeah.
So 2FA is really where you want to be.
And candidly, we have had a couple of our own clients who refused multi-factor authentication, saying that it was too troublesome, that they didn't like that second factor, having to have the phone there, and even just accepting, that they didn't like they didn't want any additional procedure that they had to go through.
But you may not have a choice. I
Well,
mean, your providers today,
some providers demand it,
demand it.
but if they
you know?
didn't demand it, they wouldn't do it.
Yeah.
So we document when clients refuse good advice, we document it. And in this case, we did document it, and both of them got hit by cyber attacks using, of course, the failure to have 2FA is what allowed them to get in. I will say the clients were splendid. They owned up to their own failure to take good advice, and they asked us if we could please come over and get that installed. But of course, it cost them. They had to recover from the attacks, and they were able to. But still, it was very persuasive to them that they did in fact need to move to MFA. Another huge and prevalent threat is the failure to patch, and there's no excuse for not taking the reasonable steps of instituting and monitor regular patching and or having a report sent to you by your IT company indicating what has been patched. Would you expand on this a little bit, John, and why this seems to be such a problem?
Well, the reason that the vendors have, updates and patches is because something's broken. They discovered something. And so it's a fix. But it's even more important today because the cyber criminals, they're not stupid. They're watching the release of information about vulnerabilities on certain products. And what do? They immediately attack those products. And the reality is that because they're so quick in attacking them, they're getting about a 50% success rate in compromising systems because people haven't patched fast enough. So that's a big incentive, if you will, to patch as quickly as possible.
John, we have a question from our previous remarks. Any way to get two-factor authentication without?
Depends on what the company uses. If they're sending SMS text messages, then no. I mean, that's how you're getting it, right? You have to give them the number. But not all 2FA implementations are SMS text. More often now, we're having options where you can do push notifications. You can use a token like a YubiKey or whatever it is, or an authentication app like Google. So when you ever connect up and you have a choice, if SMS text is the only choice you have, then obviously by all means do that. But if you have a second choice that's not SMS text, that's the one you want to pick.
And that's what we do here.
Yeah.
So we chose, of course, for the same reasons. We chose not to give up our cell phone numbers. So we don't have that particular way of authenticating using multi-factor authentication. All legal ethicists now agree that law firms have a duty to monitor for a data breach. These cyber attacks are everywhere, so we got to go looking for them. It's a reasonable measure to protect client confidentiality. So, John, for small firms, what are reasonable measures to monitor for a data breach? And please make sure you explain endpoint detection systems and intrusion detection and intrusion protection systems, because people don't understand what they mean. And I think that our audience would probably be especially grateful for lower cost recommendations. We do represent very large firms, but the majority of our clients are solo, small, mid, and therefore we're always looking for something that really works well, but not at a Cadillac price.
Well, to answer your question, there are really two categories, if you will. The IDS IPS, that's intrusion detection systems, intrusion prevention systems. Those have been around for a long time. When they first hit the market years ago, they were very, very expensive, thousands of dollars as an example. What an IDS and an IPS does is it watches the network traffic. It looks at data that's moving in and out of your network, and it acts upon that data. So it looks for attacks. It looks for types of malware injections, things like that. So that's your monitoring piece, if you will. That's the one that's in there looking. It creates all these logs, et cetera, and you can configure them to do to report, et cetera, back and forth, emails, whatever. EDR is endpoint detection and response. Some folks classify it or call it XDR, so extended detection and response, but they're both fundamentally the same thing. What that is that's a next generation of security software. It sits on your endpoint, it sits on your server, your laptop, et cetera. And it is a lot smarter than your antivirus stuff. It uses artificial intelligence, machine learning, heuristics, et cetera. And it looks for what's normal operation a computer, your laptop, its normal operation is different than a server. So it knows those baselines. And if something moves outside of that baseline, then it takes some action. Some of them are very, very robust, and they can take such action as blocking the service that's running, stopping it, quarantining it, even going so far as to take the device off the network to disconnect it automatically. Some will work with human beings. So they send information alerts to a SOC, that's SOC, a Security Operations Center. So now between the human beings and this software, you make determinations as to, is this a false positive? Is it a false negative, et cetera, and take the appropriate action. You can even roll back. So which is very, very good in a ransomware attack as an example. So if the EDR system sees that files are beginning to get encrypted and there's no user action that started this thing, it can stop that process, roll and quarantine it, notify somebody in the Security Operations Center, which can say, oh yeah, you're right, this is a ransomware attack. Let's go back to what the machine looked like 5 minutes ago before the system came under attack, and roll it back to where it was. So those are all capabilities. Now, having said all that, cost-wise, EDR systems, there are very, very expensive ones. There are very affordable ones. The CrowdStrikes of the world, Carbon Black, et cetera, those are very good products, but they tend to require hundreds of licenses. And so you're talking a lot of money. One of the products that we use, which we think is very affordable, is Sentinel-1. And Sentinel-1, you should be able to get, you have to purchase it through a reseller. You can't go out and buy it yourself, but you should be able to get that product for in the $10 to $20 a month range per machine. And that's that EDR, XDR that we're talking about. As far as the monitoring, the IDS, IPS stuff, we're really, really big fans of a product from Cisco called a Meraki. That's MERAKI. It's a combination firewall, intrusion detection, intrusion prevention, wireless access point, et cetera. The hardware itself, and I think we've talked about this previously in the previous VBA call, is it's only a few $100s. So one-time purchase, 300 and some to 400, depending on the size that you need, and capabilities. And then the software is licensed on an annual basis. We do 3-year terms. 3-year terms for the software gets that license down in the $300 to $400 a year range as well. So very affordable.
And another measure now required by cyber insurance companies is a third-party security assessment. And here they're doing you a favor. This is reasonable. It does cost money, but you can't fix what you don't know is broken. Third-party assessments are really valuable because an outside consultant does a full assessment of your network. And you can usually get this done by paying a flat fee, which includes the report documenting what was done, as well as a listing of critical vulnerabilities, which you need to fix right away, medium level vulnerabilities, which you may have time to budget for, and more minor vulnerabilities, which you can plan to address as you can and as your budget allows. Clients often request these assessments too, and they can be used as a marketing tool, not so much publicly, but within private discussions with a potential or actual client. Clients today want reassurance that their data is secure. And another important and reasonable cybersecurity measure you can take today is to offer at least once a year cybersecurity awareness training for your law firm employees. Employees are now involved in roughly 85% of successful attacks. This is very important training in a hybrid work from home world, and may even be required again by your insurance carrier. We've seen lots of those do so. To state the obvious, if you go to a large firm, of course, you're going to get a bigger price tag for that training. Smaller firms are fine as long as you make sure they have high-level cybersecurity certifications, and perhaps you want to get some references. And just by way of example, to show you how cheap it is, when we do a 1-hour presentation, it's $500 for the hour, and you can record it and save it for future employees coming in or for somebody who missed it. Employees cannot take more than an hour of cybersecurity training. Their eyes simply begin to glaze over as they try to absorb all this information. So an hour, to our mind, is the perfect time frame. the training session should include things like safe computing behavior, education on spam phishing, including standard phishing, targeted phishing, voice phishing, and SMS phishing, with some real life examples and stories to make the lesson stick and to make it all more interesting. So your employees need to understand how wire fraud happens and business email compromise schemes work. Criminals are brilliant at social engineering, so they need to hear some of those real life stories too, to hammer the lessons home. The last thing we want to talk about, and very quickly, is zero.
Allison has a question.
Oh, we have a question. I'm sorry.
Allison does.
What would you recommend using Sentinel-1 and Meraki on a home Mac computer that is not used for work phones? Would you? Yeah.
Work purposes.
Yeah.
I think if it's just for your regular home usage, that's frankly, it's kind of overkill. It's a lot to do. Now, if you're using devices, you're using a different laptop on your home network, then, I would consider at least the Meraki, because that's going to protect your home network, because you're doing business work, from the network, not necessarily from the computer.
Okay. And I want to be, I see that our third speaker has come up. I think our time is roughly out here. So we'll come back, Paul, if there's any space at the end that is you would like us to finish off, but I want to be respectful of the others. So if you could turn it over to our next speaker.
Okay, thanks, Sharon and John. I appreciate it. Always good to hear from you guys. Sharon and John have been kind enough to share some articles that will be available on the VBA PMA website. That's vba.org/PMA. So take a look at those. Always very helpful. Our next speaker is Len Heath, lawyer in Newport News and a past president of the Virginia State Bar. And in fact, during Len's year at the VSB 2019, the bar put together an important report on lawyer wellness that they have updated here for 2022 post-pandemic. And Len is going to share some of the new findings. We appreciate you coming on.
All right, thank you very much. It's always intimidating to follow Sharon and John. I'm going to share my screen here, hopefully with everyone, and make sure that, is that posted up for everyone? Yeah, hold on just a second, hit share. All right, is that posted up to everybody?
Yes, we can see it.
Okay, very good. I didn't hear a voice there. All right, thank you. All right, so Sharon knows that she is my hero. Every time I listen to her speak, she terrifies me. Everything she knows and I don't know. So what I'm going to try to do is get everybody's blood pressure down a little bit at this point and share some information with regard to lawyer well-being, and particularly with regard to a report that Jay Meyerson asked be prepared during his year as president of the State Bar. So as Paul mentioned, while I was president, I appointed a special committee to investigate what I called the occupational risks to the practice of law. When I was going to national conferences at that time, there was a lot of discussion about the impaired lawyer and how lawyers were more likely to have alcohol problems, more likely to have depression, drug use, suicide. And I would always raise my hand and say, does anybody know why? And I always got the same response. It was like, no, we don't, but let's talk about what happens when the lawyer becomes impaired. And so what I wanted to do was to at least start the discussion of why lawyers may be having these problems. And so the committee I put together was excellent. I mean, it was a large committee, very diverse, law professor, we had a judge, we had people from the State Bar, we had practicing lawyers, and they put together a report that identified 20 occupational risks. And it was, as far as I can tell, the first of its kind. And it has been used by, I think, about 16 states. so far. And prior to this going online, I was sharing with the presenters that yesterday I received a phone call from the executive director of the West Virginia Judicial and Lawyers Assistance Program. I've been invited to speak to their program in May about the Virginia Lawyer Wellbeing Initiative, which was statewide. It wasn't one person, but there were a lot of folks, including first and foremost, the Chief Justice, Don Lemons, leading the charge on this. So this report that I've got up on the screen is a follow-up to that. When Jay Myerson became president, he said his topic for the year was unfinished business. And so he picked a couple of things that he wanted to make sure were at the forefront of everybody's mind. And we put together a committee for this. Just one second. And this committee was much smaller because we were doing something more discreet. What he wanted us to do was to take a look and see exactly whether there were more risks that came up as a result of the pandemic. So it was a more discrete type of assignment. So we had fewer people, but that also meant that the people in the committee had to probably do more work than others, than the other committee did individually. I will point out Untitled Chapter, who is on the committee, is now the new wellness director for the Supreme Court. She just started that position a week or so ago. So we're really excited about that. Margaret, I remember it was Ogden, left with the birth of her first child. So Heddle has stepped in and has taken the lead again on everything wellness in the Commonwealth of Virginia. There's an overview of the results of the first task force from 2018, 2019, and we divided the risks into 4 subgroups. I'm not going to go over those with you, but again, this report has been well received, not only in Virginia, but across the nation. And we designed this report really to make sure that people were aware of the risks, because if you're not aware of the risks, how are you going to avoid them or mitigate them? And by the way, most of these risks you can't avoid, but at least mitigate and handle the risks. We also wanted the report to be a starting point for the discussion, which it has. It really has sparked a lot of discussion, not only across Virginia, but across the country. So again, here's kind of an overview. The 2018-19 committee identified 20 occupational risks. The 2021-2022 committee, we tried mightily to find any new occupational risks, but what we discovered, we initially thought we had, and then we realized that they kind of fall into the risks we already identified. So what the committee concluded was the first committee really did a very good job. And so, but what we did discover is nearly all of the previously identified risks had been exacerbated by the pandemic. There's an example I've given you there for the business management of the practice of law. Of course, that's one of the risks. And keep in mind, when the pandemic was going on, all of a sudden, we had all of these new things on the business management side of the firm. We had to deal with safety precautions, mandatory shutdowns, PPP loan applications and forgiveness forms, layoffs and reductions in force, working at home, and how to do that safely. So instead of writing a report that talked about, hey, this is how the pandemic impacted each of the risks, we decided to focus on those risks that we thought would have a lasting and continuing change. So that the report wasn't just a historical one as a look back, it really would be a forward-looking report. And so with that in mind, we identified 3 risks that we thought had lasting and continuing changes: individual work, changing legal paradigms, and lack of diversity in the legal profession. So that's what we started to focus in on. We also, and when we were preparing the report, we were mindful of the fact that what we had gone through was something very unique in the history of the legal profession. And so we wanted to memorialize in some respect what we had to go through, with the mindset that, 5 years after the report was issued, we'd all be looking back saying, can you believe we had to do all of that stuff? But again, we want to provide some historical perspective in the report. So the goals, again, there were 3: to serve as an accessible resource for those participating in the legal community, including lawyers and judges and students. Second goal was also to help those who had a loved one in the legal profession, spouses, significant others, family members. The third goal, again, was to serve as a small historical observation of what we went through. So the first risk that we focused on with permanent change was individual work. And again, this report followed the same format as the first report, using matrices. And what we found was that individual work during the pandemic, it goes without saying, the loneliest profession became even lonelier. Everybody having to be isolated. And we think that is a permanent change, because more people are going to be working from home now, maybe not full time, but at least part time. The vast majority, particularly of young lawyers, want to spend some of their working time at home. So we came up with practice pointers for individuals and then practice pointers for organizations, just like we did last time. And basically the pointers were, you have to now be proactive in reaching out to colleagues, especially those working at home. One of the recommendations is if you're working from home, go into the office several times a week to maintain relationships. Go out for lunch, schedule participation in bar association activities, and proactively schedule social time with friends and family. As lawyers, we tend to focus on work, and sometimes time will get away from us. And I can tell you that, the voice of experience. And sometimes you just have to take time to put things on your schedule to interact with other folks. Practice pointers for organizations, and we've got those up there for you. And I won't repeat all of them, but again, redouble efforts to provide mentorship programs. Interestingly, when we were going through a lot of this work, we found that while, at least at the beginning, productivity had not dropped off, there was a severe drop off in creativity. And this is not just in the legal profession, but in all professions. And one author used the term, and it was mentioned on a live chat with VBA, lack of serendipitous interactions. What I've always called the creativity of the hallway. That almost went out the window during the pandemic, and it's more difficult with the permanent changes from the pandemic, again, working from home. So the second risk, again, that we thought there were permanent changes, changing legal paradigms. And really, there were 2 major changes in legal paradigms. One is home office syndrome, and the other is Zoom fatigue, interestingly, as we're on Zoom right now. So home office fatigue is the stress and exhaustion associated with blurred boundaries between work and home life, and Zoom fatigue, burnout associated with overuse of virtual communication platforms. And we were really careful in this report. The term Zoom fatigue is not derogatory of Zoom. I went to business school before I went to law school, and I remember a case study in a product called a Band-Aid. A Band-Aid actually is a proprietary product, but it works so well that society used that word for everything that covered a wound, even those not made by Band-Aid. So Zoom fatigue, Zoom was so successful that we use Zoom to mean any type of virtual presence. And in fact, we even not used it as a noun, but as a verb, let's Zoom later on. So again, those are the 2 changing legal paradigms that we thought had significantly changed the practice. So we gave pointers with regard to home office syndrome. And again, create boundaries, psychological boundaries between work and home, create a dedicated workspace. And right now, I'm working out of my home office, which looks nothing like a home office. Everything behind me is Disney. It makes me happy. But everything in this office is technologically advanced, including my son who's sitting in the corner to make sure everything works right while I'm doing this. We're very secure here, but it's a dedicated space. I only come in here when I'm working. When I leave, everything else is home. Establish start and end times of your workday. Follow routine that replicates the rhythms of being in the office. Some people find wearing different clothing makes a difference. And establish a routine to transition from the work mode to the home mode. For most of us, that had been a drive to work and a drive home. And there is some value to that, to decompress. And if you're just walking out the door, going to the next room, there's not much time for that. But just be mindful of this. Again, we've got practice pointers for Zoom fatigue. Again, I won't go over each one of these. By the way, we posted this to the VBA site, and the full report is at the Virginia State Bar site. But the thing that I was fascinated about with Zoom fatigue is the studies that come out when you're on the Zoom, you spend more time looking at yourself than the other people for whatever reason. And they've done studies on this, and even that can be exhausting. So again, here are some pointers for handling Zoom fatigue. Here's the practice pointers for the organizations, for the home office syndrome. And again, I won't go over all of those. But again, and I'll add in something that Sharon drove home during the pandemic. You have to have secure home offices. But these are pointers here that are designed to help bring your wellness or improve your overall wellness. And here's a practice pointer for organizations for Zoom fatigue. And again, there's actually software that minimizes harms from extended use of screens. And if you don't know that there's problems with extended use from screens, then when you start experiencing problems, you don't know why. So again, we're identifying issues and giving pointers in this report. Lack of diversity was the third issue, and I put everything on the one screen here. The diversity initiatives in the legal field really were slowed down as a result of the pandemic because everything was slowed down. So we had to be very mindful of including diverse ideas, diverse individuals, diverse beliefs. And even today, when we're putting on programs, virtual programs, I think the most important thing that came to my mind is the last point under practice pointers for organizations. That last bullet point, virtual communication should be evaluated to ensure diverse participation, not only as to the attendees, but also to the organizers and the presenters, to be mindful that you're promoting diversity when you're putting your programs together. I threw in this is not part of the report, but the importance of voluntary bar associations like the VBA cannot be underestimated. The first report that came out of the 20 occupational risks, eight of them in the recommendations included recommendations to participate in a voluntary bar association. And we gave the reason why for each of those. So here are the 8 occupational risks that we said, being a member of the VBA or VBA, any voluntary bar association, a local bar association, a specialty bar association could help. Adversarial nature of work. It's nice to be able to sit down at a table with someone you're constantly on the other side of the case of, and sitting and talking to them about something other than a case, finding out who they are. So again, those are 8 risks that were mentioned, but there's a 9th now, because the VBA is addressing one more of the occupational risks, and that's the business management of the practice of law. So at least with the VBA, they're addressing, 9 of the 20, at least that I could identify. So it's important to be involved in voluntary bar associations to promote your lawyer well-being. I always leave with this line: be well, do good. Can't be more succinct than that. This initiative has been important. It has changed the profession. Hopefully what we continue to do will help educate people on how to take care of themselves. And again, this was Jay Meyerson's idea. He deserves all the credit for the vision of following up on this particular report. So, and that is it for my presentation.
Len, thank you so much for coming on and sharing this leadership that you have shown us on this important topic has been very valuable, and we thank you for that as well. You can see in the chat that the PowerPoint, along with the updated recommendations post-pandemic, is going to be available at vba.org/PMA under the useful links section. We also have posted the original report there, so please take a look at that for both your own well-being and for that of your firm. Our final guest today is Patrick Bolling, a labor and employment lawyer with Woods Rogers, Van Deventer Black in Lynchburg. And Patrick is going to report today on some updates and things to be aware of with whistleblower statutes. So Patrick, please take it away.
All right. Thank you so much for having me, Paul. I'm happy to be here. And I'm going to talk about today, in 2020, there was that you can everyone see my screen?
Yes.
Share the actual language of the statute. Okay. All right, good. So this is what we're in the employment bar have come to call the general whistleblower statute. And I'm going to talk about, I'm a management side labor and employment lawyer, and I'm going to sort of run down sort of some reports from the front here, because a lot of employment litigation in the state is shifting to state court, which is unusual because in the past, typically all employment litigation, at least that I was trained on and was involved in up until 2020, has proceeded mostly in federal court. And I see Craig Kerwood on here, so I'm sure that he's going to immediately give this recording to one of his associates to start coming up with all the reasons that my arguments here are wrong. But we'll deal with that later. So I've got probably, since this law was passed in July of or enacted in July of 2020, I've probably had a little over a half dozen of these lawsuits, and so some of the parameters of this law have started to take shape. And I'm sort of going to, share a little tradecraft here on some of the ways that we've been able to, on demur so far, pare down these lawsuits. So, the reason I would say that this is a big deal, this development, the passage of this law, is that in the past, when employment litigation has proceeded, it's almost always done so in federal court, where you can use a plaintiff's deposition transcript in support of a motion for summary judgment, which is a tremendous advantage to the employers often, who can sit down with the plaintiff for a full day, hopefully seek enough admissions to put together a summary judgment motion that will allow the court to dismiss the lawsuit before you proceed to trial. But of course, everyone knows that except for some limited circumstances in state court in Virginia, you are prohibited from using a plaintiff's deposition transcript in support of a motion for summary judgment. The exceptions are if you move for summary judgment in connection with punitive damages, you can use a plaintiff's deposition transcript. That's 8.01420. And then I believe you also, in a business-to-business dispute, you can use a plaintiff's deposition in connection with a motion for summary judgment, which wouldn't apply to an employment lawsuit typically. So you're now proceeding in an unfavorable forum to employers, and so we've had to come up with sort of some creative ways to defend our clients here. I'll say, we can just look at the code language here to start out, and if you look at section A here, these are the things, in a whistleblower complaint or whistleblower action, retaliation action, you really need three main components. You need an employee's protected act, you need an employer's retaliatory act, and you need some causal link between the two of them, right? And so if you look at section A here, these are the things that an employer is prohibited from doing. These are the employer's prohibited acts, right? Discharge, discipline, threaten, discriminated against, penalize, or take other retaliatory action regarding compensation, terms, conditions, location or privileges of employment. And then there's a list of 5 things that are the employee's protected activities. So if they in good faith report a violation of state or federal law, which is huge, the fact that they included federal law in this statute. I'll call number 2 the subpoena provision. If they've been requested, notice not if an employee has actually participated in any investigation or hearing, but just if they're requested to participate in a hearing. If the employee refuses to engage in a criminal act that would subject them to criminal liability, or refuses to perform an action, an employer's order to perform an action and then it simultaneously informs the employer that they're not doing whatever it is that they're refusing to do because they believe that it would violate a state or federal law. Or if they testify to a governmental body or in connection with an investigation, say a Bosch investigation or something like that. There are some kind of, section B contains some affirmative defenses. An employee is not going to be permitted to disclose trade secrets or other privileged information, for example, make sort of false, reckless accusations, or permit disclosures that would diminish or impair the rights of any person to the continued protection of confidentiality of communications. So this is really, I think, aimed at attorney-client privilege, maybe a board privilege, something like that. But there's an issue here. I'll start with the first area that we've been able to have some success with is because this law was enacted on July 1, 2020, and then we've been able to use the doctrine of retroactivity in order to certainly have dismissed on demur any allegations, any retaliatory act that occurs before July 1, 2020. That's pretty clear, and we haven't had a lot of pushback from judges or opposing counsel with respect to the fact that if an employer is alleged to have, say, discharged someone before July 1, 2020, then very clearly the cause of action is accrued before July 1, 2020, and that would the doctrine of retroactivity would bar that action from proceeding under this statute. An area that's a little bit more contested is our position is that if you've got a protected activity that occurs, say in 1950, someone that's an employee of yours, a longtime employee, testified in some government action, and in 2030 they're discharged, or 2025, the retaliatory act takes place after July 1, 2020, but the protected activity takes place long before July 1, 2020, when memories that will have faded, documents probably will have legitimately been lost or destroyed, decision makers may have moved on. And so we've made the argument with some success that, look, any facts that have developed before July 1, 2020 can't contribute, they can't be part of the set of facts that meet any of the elements of this statute. And therefore, even if a retaliatory act takes place after July 1, 2020, based on facts occurring before July 1, 2020, then liability can't attach. So that's one avenue that we've gone down with some success. And I'll tell you that in a lot of these, judges have been very clear that they think that the Supreme Court's going to have to speak on it, and I think they're right. This is a new law. This is going to be. It's been read by the plaintiffs' bar to be pretty expansive. For example, if you look at number, A1 here, if an employee in good faith reports a violation of Title VII to an employer, then the employee can proceed under state court under this law, even though they've reported a violation of federal law. And so it's been interpreted by the plaintiffs' bar broad enough to pull almost all federal litigation over employment issues into state courts. And so I think we will see a lot of this is going to have to go before the Supreme Court before we really get clear answers on the parameters of it. Those retroactivity cases in Virginia, that'd be Berner v. Mills, and the U.S. Supreme Court has sort of a corollary case called the Landgraf decision. There's also a question here that we've challenged of what damages are available under this statute. And if you look at Section C, you'll see that you've got a 1-year statute of limitations, and you've got this section here that deals with what remedies are available. So the remedy is an injunction, equitable relief, reinstatement, which is equitable relief, compensation for lost wages, benefits, lost wages and benefits, and there's a pretty solid case precedents on that those are also equitable remedies. And then you've got this word here, other remuneration. And the question that has been posed is, well, what is other remuneration? Does that include things like compensatory damages, like emotional pain and suffering, emotional distress, et cetera, et cetera? And our argument, and we've been successful with it, has been that it doesn't. And, we've made the argument that your remuneration really means quid, as it shows here in Black's Law Dictionary, quid pro quo, that is really payment for a service that we're talking about, not these sort of tort style damages, compensatory, emotional pain and suffering, and that sort of thing. And the courts have largely agreed with us on that this is these are equitable remedies, and this is an equitable statute. Another issue that has come up is whether a plaintiff is going to be entitled to a jury trial under this statute. We made a number of arguments in connection with this. There's a Standardsville, there's a Virginia Supreme Court decision, the Standardsville case, that says that the only matters that can proceed to a jury in the Commonwealth of Virginia are causes of action that existed at common law. And so that means that if it didn't exist basically in the founding of Virginia as a cause of action, then you're not entitled to a jury trial on it. And in Virginia, there's a few other cases that say that there's no common law cause of action for retaliatory discharge, and most certainly not then for a retaliation either. We have made this argument. Judges have been reticent to pull the trigger, but there have been a lot of, when we've made this argument, taking it under advisement. And I think the judges that have heard this argument, I think that there's merit to it, but are a little bit hesitant, understandably, given the language of the Virginia Constitution, to sort of cross that line of the jury trial being held, inviolate, basically. Another argument that we have made here is that the language of the statute here indicates that the court may order, not that the court or a jury may order. And the argument that we've made that on the same day that, is that on the same day that this law was enacted, July 1, 2020, the Virginia Human Rights expansion was also enacted. And in the expansion of the Virginia Human Rights was included language that says the court or jury may order, and then it goes on to explain the remedies. And so the argument is, well, if the General Assembly wanted the court or a jury to hear these cases to decide liability and or damages, that it very clearly could have included that language here, but didn't. Another argument we've made is that these are all equitable remedies, and sort of along the same vein as the common law jury trial argument, that equitable remedies are matters for the jury, for the judge, and not the jury. And so we've had some success with that. I'll talk about the last point I want to make here is the issue of what the standard of a causal connection is. So earlier I pointed out that you've got to have an Employees Act and you've got to have an Employers Act, and you've got to then have some connection between the two of them. So the question then is, what kind of connection are we talking about? The language that's used here is that the Employers Act, the employer is prohibited from acting because the employee has taken this list of 5 actions, right? So what does because mean? Under Title VII, the standard is but for causation, which many federal courts until recently have interpreted maybe a little too aggressively to mean sole cause. So but for, it wouldn't have happened but for, the employee wouldn't have been discharged but for their complaint about working conditions. I know the Sixth Circuit has a case where they interpreted the but for standard of causation to mean sole cause, that it's the but for causation. But in the Bostock decision, Justice Gorsuch wrote some language that indicated that no, that's not true. You can have multiple but for causes. So I think then logically it sort of becomes an issue of proximate causation. So there's going to have to be a discussion in any, if you bring demur on this issue as we have, a discussion of, well, what is the standard of causation and how do you prove it? Typically under Title VII, how it can be proven in a number of different ways. The causal connection can, you can prove it solely by resort to an argument of temporal proximity, that the employee made a complaint, a couple of days later, a week later, a month later, there was a retaliatory action of some sort or another. But if you get too far, the Fourth Circuit said 3-4 months between the employee's action and the employer's action, then the temporal proximity argument becomes weaker, and you have to have some interceding events like a discriminatory comment by a manager or something like that to sort of bridge that long temporal gap. And so I think that we've made some of those arguments as well. And I think there's going to be a question of, when these cases are litigated, the extent to which circuit courts are going to be willing to rely on a huge amount of case law that exists under Title VII in federal courts. So that's a little bit of a report on where we are with this. And I thank y'all so much for having me. There might be a question.
Thank you. We appreciate hearing that update. It's always valuable to have a sense of new laws that affect employment, because law firms are employers, and lawyers can advise clients as well when there are changes in the law like that. That's our call for today. I want to thank Sharon and John and Len and Patrick, all four, for coming on today's call. This is some great information. This call has been recorded and will be available on the VBA PMA site as well. If anybody wants to review it, or you want to refer someone to it. 2 items for your calendar to keep in mind. On the 24th of October, we're going to be hosting a PMA webinar from our friends at Affinity Consulting called 8 Things Killing Your Law Firm and How to Stop Them. That should be interesting and valuable. And then the next PMA live chat call will be on November the 18th. That's a Friday again at 10 a.m. Thank you all for coming today. Thanks to our presenters one more time. Have a great day, everybody, and we'll see you next time. Thank you.